Now recognize the gentleman from North Carolina, Mr. Bishop, for his 5 minutes questioning.
Thank you, Mr. Chairman. Ms. Dunn, I was watching you as we listened to my friend from New York just now and heard what you said. You did a fantastic job sort of defeating his point in the little bit of time he gave you. But as he was saying that they make the issue that Republicans aren't sending more money to the border. What every jurisdiction in the United States, notably New York, Chicago, and others are suffering is a deluge of immigrants that the country cannot assimilate, that are not prepared to be assimilated culturally, by linguistic background, by experience. They're not. We can't get the job done that way. The only proposals that Democrats have offered, let this go down on record. The only proposals that have been offered is to send more money to the border, which will be used to process more immigrants faster into the country, number one, or number two, to legalize them all, grant them amnesty, as if that would somehow address any of the problems that we're experiencing. Not one of them would be addressed. So I appreciate, Ms. Nobles, you and Ms. Dunn, you for being here. It must be particularly infuriating to hear that when you've suffered the ultimate victimhood from the violations of law that the Secretary of Homeland Security has administered. So, Professor Pearlstein, I want to go to you, though, because I want to talk about that victim, the rule of law. You said in your paper in defense of Secretary Mayorkas that to the extent the majority of reports, allegations against the Secretary are related to those policies, in particular the suggestion that Secretary Mayorkas somehow exceeded the scope of his lawful authority to set priorities for the enforcement of U.S. immigration law. That claim has been rejected most recently by an overwhelming bipartisan majority of the U.S. Supreme Court. Now, are you referring to the United States versus Texas case from last June?
I am.
But there, the majority opinion says, quote, "We take no position on whether the executive branch here is complying with its legal obligations. We hold only that the federal courts are not the proper forum to resolve this dispute." So when you read that language, how do you come to the conclusion that the court decided that Secretary Mayorkas is acting in accordance with his legal responsibilities?
The basis of the court's ruling on standing that you just described was, as Justice Kavanaugh's opinion for the majority said, the authority to decide how to prioritize and how aggressively to pursue legal actions against defendants belongs to the executive branch under Article 2. That was the basis of the ruling that there is no standing in this case.
Well, they also said they've taken no position whether the executive branch is complying with its legal obligations. How is that?
Trump appointed said this is authority that belongs exclusively to the executive branch.
Right. What you're referring to is the court says we're not in the business of refereeing anything where the executive has any amount of prosecutorial discretion. But they also say we're not deciding here whether the executive branch is complying with its legal obligations. Both of those propositions are true. They're both in the opinion, are they not, ma'am?
The court found that there was no standing because—
No, ma'am. I asked you a question. This proposition is in the opinion as well, correct? I read it. It's accurate.
The court found there was no standing. That is also true.
I didn't ask you about standing. I asked you whether this language that I just read, where the court said we're not determining whether the executive branch is complying with its legal obligations, that's also in the court's opinion, correct?
That may be in the court's opinion, but
that's what I asked. Thank you. Let me ask you this. At the oral argument, this was Justice Kavanaugh's question to the Solicitor General. Solicitor General of the United States. I think your position is, instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps if some administration comes in and says we're not going to enforce laws, or at least not going to enforce the laws to the degree that Congress, by law, has said the laws should be enforced. And that's forcing, I understand your position, but it's forcing Congress to take dramatic steps. Isn't that what he said at oral argument?
I don't have the transcript of oral argument.
All right, do you disagree with his proposition as I just recited it to you?
Justice Alito said in his lone dissent that impeachment, along with funding cutoffs and others, were among the potentially available remedies that Congress has. The majority opinion, none of the other 8 justices, including all of the justices appointed by the former president, mentioned impeachment in that context.
So are you familiar with the Illegal Immigration Reform and Immigration Responsibility Act of 1996?
It's a large act. Which part?
The part that the United States Supreme Court considered in United States versus Texas?
I've read the case.
Okay, you know that, as Justice Alito describes in the dissent, that in that situation, the Congress decided to withdraw some of the discretion that the executive has by requiring detention and specifically in certain cases, right?
What the court said was that for the last 27 years since that law was enacted in their current form, all 5 presidential administrations have determined the resource constraints necessitated prioritization in making immigration arrests.
If you evaded a question like that before the bench, they would not like it. I yield back, Mr. Chairman. My time's expired.
The gentleman yield.